Swayam Prabha. Digital India. Educated India.
Welcome to the course on Introduction to Law and Electricity. This is a course which is being floated under the aegis of NPTEL online certification course. I am Uday Shankar, Associate Professor at Rajiv Gandhi School of Intellectual Property Law, Indian Institute of Technology, Kharagpur. In this course, we will take you through the fundamentals of the Electricity Act 2003, and we will explain to you that how the law related to electricity has evolved over a period of time, and also what are the challenges for successful implementation and including the shortcomings under the laws. Before we start the discussion on the statutory framework related to electricity laws, I want you to give an overview of the constitutional scheme related to energy generally and electricity in particular, and then I want you to also understand the significance of access to electricity in the larger understanding of rights based jurisprudence. The reason being that electricity in today's context should not be only seen as a commodity to be tradable in the market, but then it should be seen as basic amenities needed to lead a decent life. And therefore, as the course progresses and we start discussing the statutory provisions, we want the learners to develop the understanding on the premise of the very significance of access to electricity and how the statutory interpretation should take place for achieving the larger goal of fulfillment of the rights for everyone, especially the marginalized section of the society. And that is why at the very beginning I want to give this description to all of you on the constitutional scheme. Now, these are the concepts which we will be covering: the constitutional framework on the electricity and energy aspect, then what are the different phases of the evolution of the laws on electricity, and then in the first module we will also take you through the salient features of the Electricity Act of 2003, so that we right at the beginning get the idea that how the legal provisions have transformed in this sector. Now, to begin with, on the constitutional structure, Constitution is generally considered as a supreme document. This is said to be the suprema lex. Every law needs to comply with the Constitution. Any law enacted by the legislature runs to the contrary of the constitutional scheme is void and it does not have any legal effect. And that is why we need to understand the very significance of constitutional scheme to understand that what are the responsibilities lie upon the center and the states in relation to electricity. The Indian Constitution is primarily said to be a federal in nature, which divides the power between the center and the states. States enjoy autonomy in the spheres which are being specifically demarcated, and center is generally been not allowed to encroach unless and until it complies with the necessary constitutional conditionalities led therein. Now, for building upon that division of power, the Constitution provides for 3 different lists. List 1 of 7th schedule details out the subject matters on which the center can make a law. List 2 has a subject matter on which state can make law, and then we also have a list 3 in the 7th schedule, which provides for the concurrent list where both the center and state can make law, but then central law shall prevail over the state law as and when conflict arises between these two. This is what is the constitutional solution suggested in cases of conflict between the central law and the state law. Now, what is the significance of concurrent list? The significance of the concurrent list is that many a times it is desirable to confer the necessary legislative power on the states, maybe for the very purpose that subject matter is such where necessary leeway is to be given to the provinces, but at the same time center is also been assigned with the necessary legislative competence to interfere, and the same is possible or same is permissible when uniformity is needed in the main principles of law, when the center needs to guide and encourage the effort of the state governments, or when there is a need to remedy the mischief arising in the provincial sphere, or where the action of one province is adversely affecting the other provinces or the nation or the interest of the nation in general, then in that situation the center can very well intervene and make a law on that subject. And electricity is one example which falls under the concurrent list, wherein it is advisable that center should step in where the problem extends beyond the boundaries of the states. And in order to give the necessary confidence to the investor, it is also desirable to have a uniform legal framework across the country, and therefore entry 38 of list 3 of the 7th schedule describes electricity as a as a subject. Now, in general, before I come to electricity, when I look at the framework on energy, it can be located under 2 different paths. One which deals with coal, petrol and gas which are derived from minerals, and the second one is relating to electricity. Now, looking at the subject matter's significance, both the center and the states, they are being assigned exclusive power to deal with the subject. Now, list 1 of entry 54 empowers the parliament to make a law to regulate mines, mineral development, to the extent that such regulation and development under the control of union is declared as a matter of public interest. Then in such situation, it is the parliament which shall be making the law, and the parliament has enacted the law to regulate the mine sector. Then we have list 2 entry 23, where we find that the mines and mineral development is also been conferred upon the state. Obviously, that is subject to list 1, that is entry 54 of the list 1, that whatever is already been declared as a matter of public interest to be dealt by the parliament, that is excluded from the domain of the state legislature. And then for our purpose, which I was stating a while ago, list 3 entry 38 describes electricity, and as I said that on this subject both the centre and the states do have a jurisdiction, and we would find in our course of a study that how the centre and the states, they are collectively regulating the area related to electricity. And in general, when you look at the energy segment and how the energy sector has been performing in this country, you would find that we have a very diversified sources. We do have a sources for power generation in India from conventional sources like coal, lignite, natural gas, oil, hydro and nuclear power. And nowadays there is a promotion done for bringing in renewables for making our dependency on import of conventional sources minimal. So, we do have both the conventional sources of energy and renewable sources of energy, which is meeting the need of the country. And as I said that electricity sector in India is under the concurrent list, and both the governments, they do have a power, particularly when you look at the arrangements, when you look at the responsibilities, you would find that the distribution segment is largely under the control of the state governments, and it is the state which closely regulates that distribution segment, and the approach of the state government decides the efficiency of the sector. Having said so, there has been effort made by the central government from time to time that how to popularize the reform, how to effectively bring in the reform in that sector, which we will be discussing in our course at later point of time. But then at this stage, when we are discussing the constitutional framework, I want to make this very clear to all of you that when it comes to distribution, it is largely under the control of the state. Along with this, even intra-state transmission is under the control of the state, but then we have a broad regulation in place which is drawn from the Electricity Act of 2003, which certainly we will be discussing as we move on with the course. Now, before I start discussing on the evolution of electricity laws in this country, I want to highlight the significance of rights based understanding. The reason being that electricity is essential for leading a meaningful life, and thus any attempt to interpret the law or any proposal to reform the sector must have the alignment with this understanding of rights based jurisprudence. And that is why I want all of you to also get an overview of the rights aspect related to right to access electricity. Now, the argument has been built on the premise that access to electricity is to be considered as a part of right to life, which is a celebrated provision given under the Constitution under Article 21. Article 21 says that no person shall be deprived of the right to life and personal liberty without procedure established by law. Now, over a period of time, the Supreme Court of India and the High Courts have given very expanded meaning to the term life. The court highlighted that the significance of life must not limited to bare minimal existence. It is not about existence similar to the existence of other living creatures. It is more than that, and therefore, whatever is needed to lead a dignified life where autonomy is regarded, where self fulfillment is regarded, it must be considered to be integral part of right to life. Now, in this regard, we also need to understand that rights are generally to be seen from two perspectives. One is the rights is specifically included in the constitutional text, and the other which has been acknowledged through the judicial process and has become part of the larger gamut of the right given in the constitution, which we also call it as unenumerated rights. Now, it is not that right to access electricity is being advocated as a part of right to life as only essential integral aspect of life. On earlier occasions, the courts in this country, particularly the Supreme Court, very justifiably recognized several aspects of dignified and decent life as a part of right to life, such as right to health, right to shelter, right to food, right to social security, right to education, which is now being which has now been recognized as part of constitutional right. Now, it is one of the fundamental rights under 21 capital A. So, there has been such recognition done of expanding the list of rights given under the constitution, and in that series right to access electricity also to be placed. In order to build the argument on this, I am taking help of some of the decided case laws. As I said that much of the recognition has taken place only through the judicial process, and therefore, it is better to look at some of the judicial pronouncements which will strengthen the argument to consider right to life, consider right to access electricity as an integral component of the right to life. Now, in this case of Calcutta High Court, where Molay Kumar Acharya approached the electricity distribution company for getting a connection in his house. The connection was denied to the petitioner on the very ground that there is some property dispute going on, and therefore, unless that gets resolved, there shall be no electricity connection provided to him. Now, the court here very rightly looked into the statutory obligation of the licensee under section 43 and directed the board to provide electricity to the petitioner as long as he remains in the possession of the property. But for our purpose, the observation based on article 21 is very pertinent. The court categorically said that no one can survive without electricity in modern days. And in the language of the code says right to electricity is also right to life and liberty in terms of Article 21. So, look at the way the code is uplifting the status of electricity and drawing it parallel with the amenities needed to lead a meaningful life. So, in this case of T.M. Prakash versus the district collector and the superintending engineer Tamil Nadu State Electricity Board, the laundry workers, more than 115 numbers, they were staying in the government lands, and for over 2 centuries they were staying in huts. Their children were going to schools, colleges, and therefore they demanded for supply of electricity to their huts. Now, the board asked them to obtain NOC from the district collector's office, and obviously they could not manage NOC, and thus the board refused to supply electricity to them. They approached the Madras High Court, and Madras High Court in this case again reminded the board of the statutory obligation under section 43, where there is a duty of licensee to give supply of electricity to owner or occupier. And apart from that, the court stressed upon this very fact that before denying the supply of electricity to the petitioners, the board ought to have realized the condition of life they are leading in that hut without electricity. And therefore, the court said that electricity supply is so essential, so fundamental, an important factor for achieving socio-economic rights. The court built upon this. Court said that food, shelter, clothing alone may be sufficient for leading a life, but then in order to make it valuable, meaningful, making decent, electricity is needed. If you deny individual the supply of electricity, then it has a very fatal consequences connected with many rights which are given in the constitution, be it the right of equality, be it the right of education, to compete for a suitable employment, the judicially evolved right to health, judicially evolved right to sanitation, and other rights. And therefore, the court has said that without providing the same, without providing the electricity, the board is denying them the goals which are enshrined in the constitution, such as justice, liberty, equality, and fraternity. He said that how they can achieve this? How do you expect a person who is living his life in darkness to really come forward and compete with the whole world? So, that is what is the significance of right to electricity. The court highlighted and instructed the board to not to look into this very aspect, that whether they have got NOC or not. The court said that immediately provide them the supply of electricity. Now, same is the case from other high courts also. Now, let us look at what the Himachal Pradesh High Court has said. Now, here again in Madan Lal case, the petitioner constructed a house on a land which is alleged to be owned by the state, and there was an eviction notice which was given. The petitioner contested the eviction notice. There was a dispute going on with regard to the proprietorship. Meanwhile, the petitioner approached for the supply of water and electricity. Because the municipal council refused to give the NOC to the petitioner, the board decided not to supply electricity. Interestingly, in this case, the High Court frames this question that whether the petitioner should be allowed to have basic amenities of water and electricity, which is considered as an integral part of right to life or not. So, in Madan Lal case, the court itself is framing the question and answering this, that water and electricity, they are basic amenities, and court said that these amenities are to be provided to the petitioner until the title over the land gets decided, because the court said that if the petitioner fails to establish the ownership over the land, anyway the residential house will be also taken away. So, there will be no question of continue with the water or electricity supply. Another case from Kerala High Court of very recent time. In this case, the applicant applied for electricity connection to his new house, which was merely of 300 square feet or so. The connection was denied to him on the very ground that his house was not falling within the distance from where the low transmission connection was to be given, and on this technical ground the board refused to give him the connection. Now, the court said that this cannot be a reason to deny him the basic amenity, and court also reminded the board of its statutory duty laid down under section 43. This case is very important because in this case the court sets a very remarkable narrative in favor of access to electricity. It is a case which was filed to oppose the commissioning of nuclear power plant situated at Kundakulam in Tamil Nadu, wherein through public interest litigation petitioner argued that commissioning of the power plant will have very damaging effect on the environment and the life of the people living in surrounding areas, and thus it would violate the right to life. Now, the court stressed upon the need to balance the right to life and property with protection of environment, and the court made this remark that larger public interest of the community must be given precedence over apprehension of an individual on the violation of his human rights. It is merely apprehension, and therefore it would be wrong to overlook the public interest it would serve by generation of the electricity from that nuclear plant and providing light to many houses and to provide electricity to multiple industries in that region and far away. And therefore, on that premise the court said that in order to economically prosper we need electricity. In modern life, that is what is heart and soul. a life is not only meant for the one who is resourceful, but also for poor and downtrodden, and that is possible only when the country sees economic growth. And economic growth is possible only when there is sustainable, efficient and quality supply of electricity, and nuclear power is certainly a viable alternative in that direction. And therefore, the court in this case said that nuclear power plant is being established not to negate right to life, but to protect the right to life guaranteed under Article 21. So, very fundamental observation by the court in this case. And then last in the series of the case to establish right to access electricity as a part of right to life, I quote this judgment of Chameli Singh, which again is from the Supreme Court, where the matter was of land acquisition, but then for our purpose what is important that the court truly accepts that how electricity is an integral part of right to shelter, which is acknowledged as part of right to life. So, the court in this case says that right to shelter includes adequate living space, it includes safe and decent structure, clean and decent surroundings, sufficient light, pure air and water, electricity, sanitation and civil amenities. And the court says that it is not only about animal needs of man, it is more than that. And what is more than that is availability of basic amenities which fulfills the meaning of life for individuals, and it matters more for the one who are standing in the end of the queue in the social strata, and there electricity is really certainly going to access to electricity is certainly going to play a role. And therefore, we need to understand this when we are analyzing, when we are interpreting various provisions of the Electricity Act 2003 in today's context. Thank you for listening.